In California, there are different types of custody. You can have legal custody and you can have physical custody. Legal custody involves making decisions based on what's best for your children's health, safety, and education and general welfare. Typically in California, parents share joint legal custody, meaning they each have equal rights, equal opportunity to make these kinds of decisions. And oftentimes, they make these decisions jointly together in order to do what's best for your kids. Sometimes, you and the other parent might not be able to reach agreements on what's best for your kids. Just because you're not able to reach agreements doesn't necessarily mean you both shouldn't continue to share joint legal custody. If you can't reach agreements, maybe you have an attorney negotiate with your spouse's attorney to reach agreements, or you escalate it to a judge in order to make a decision, but you both maintain that joint legal custody. Sometimes you might have a parent who is not able to make decisions that are best for your children. And if your spouse is unable to make those decisions that are in the best interest of your kids, or if you're no longer married, if the other parent is no longer able to do that, that is a time when a court may find that you should have sole legal custody and your spouse would not have any legal custody. This is pretty rare in California. It's a high bar. Typically, if you're getting a domestic violence restraining order or if you're getting emergency custody orders, those are times when potentially a court might give you sole legal custody where your spouse doesn't have any decision-making authority. Other times, a court's not going to want to completely strip your spouse of decision or the other parent of decision-making authority, but maybe the court wants to strip the other parent of decision-making authority over, one matter. Like maybe the other parent can't make any more decisions about the medical issues involving your child because the other parent has made some pretty bad decisions or is not being able to facilitate the right decisions if your child needs medical care. That's pretty serious and pretty critical for your child to be able to get good medical care. So if the other parent is blocking that, sometimes a court will say, sorry, you don't get to make those decisions anymore. So that's legal custody. I've also seen where a court will say only one parent gets to make decisions about where your kid goes to school because you guys can't seem to reach agreements. And so we're just going to choose one parent has that right. The other parent no longer has that right. It's not a forever situation. It's usually temporary. I've seen the courts give one parent the right to pick elementary school. Next parent gets the right to pick middle school. It just kind of depends on your situation. If the other parent is a really bad parent and just can't, maybe has mental health issues, maybe substance abuse issues, maybe just has very illogical, unrealistic beliefs about what's best for your kid that's really not in line with the reality, maybe that parent's not meant to be making these kind of decisions, and a judge will see that. It's hard to take away a parent's right to make decisions about a kid. So if it's a really complicated issue where it's going to be hard for a judge to really understand, those are times when you might want to do a child custody evaluation where a mental health professional can kind of evaluate your spouse and determine, or the other parent, and determine kind of what would be best for your kid as far as who makes decisions about your kid's well-being. The other type of custody in California is physical custody, which is kind of what it sounds like. It's who physically has custody of the kid. Even if the other parent doesn't have legal custody, maybe the other parent still gets to, see your kid. Physical custody can be, joint, where you each share physical custody, or only one parent can have physical custody and the other parent doesn't have any. It's pretty rare for the other parent to not be allowed to have any physical custody of the child. That might be in a very intense domestic violence kind of situation where the court has found it's simply not safe for your child to be with the other parent. But typically, both parents, get to share physical custody of the kid. Physical custody can be unsupervised, where, you each get to have parenting time based on some sort of schedule at your house or, and be involved in your kid's extracurricular activities and everything else. Or maybe the other parent has had some domestic violence concerns or other concerns where the court's ordering supervised visitation, where the other parent can only see your kid with the help of maybe a mutual friend or third party, or in more serious situations, maybe a professional supervisor, which is a professional that's trained to supervise children and write reports afterwards so that you and the court can read the report and say, okay, like he or she was safe with the kid, looks like he or she is doing pretty good. If a parent starts with supervised visitation, doesn't mean it's always going to be supervised, right? People change, people get better, people heal, or at least the court system believes they do. So, you should expect over time, likely, that the supervised visitation will evolve into, a tiered kind of step-up plan where eventually the other parent gets to have unsupervised visitation. Most cases resolve where parents have 50-50 custody, right? They share joint legal custody and they share joint physical custody, and it's a pretty equal split. That doesn't mean that your case will resolve that way, but that's just the standard. And you should know that that's the standard because, generally most parents are able to be capable, safe parents to their kids. If the other parent of your kid isn't a capable, safe parent with your kid, then I don't want you to think that that 50-50 custody is going to apply to you. I want you to know that you might very well have specific circumstances that would warrant a court to limit the other parent's custody rights to your kid. So I don't want you to listen to the stories other people are telling you and let that stop you from, getting the advice of an attorney and really learning what your options are. Because if you're worried about your child's health, safety, and welfare, and you're worried about the other parent's decision making when it comes to your kid, you need to take those fears seriously and learn about your rights. Because what I tell our clients is if you're not going to protect your kid, who else is going to do it, right? This is in your hands to make sure that your kid is going to be okay. And if you bring your case to our firm, we will do everything possible to make sure that your family is okay. Deciding what's best for your kids, sometimes it's hard to do in isolation. So often we involve custody consultants that we meet with you to help us determine the best plan of action, and we involve other mental health professionals. You don't have to do this alone, but you should get help and involve attorneys and mental health professionals in order to do what's best for your family during this difficult and scary time. In California, the best interest of the child is the standard that the courts use in order to determine what custody orders to make or what orders to make related to your kid, what school your kid's going to go to if you're fighting over what school your kid should go to, who has your kid on different holidays, who's going to have parenting time and get to take the child on vacation. Every time the court has to make a decision related to how you're going to share custody of your kid, it goes back to that best interest of the child standard. And this is a very subjective standard, right? What I believe is best for your kid might be a little bit different than what you believe is best for your kid, right? And so you have to imagine that if you're unable to reach agreements with the other parent, the person that's going to decide this is going to be the stranger on the bench, a judge. Right? So in the best case scenario, if you're able to reach agreements with the other parent, that's great if you align and you can both agree what's best for your kid. But, if you're needing help from a divorce attorney, it probably means that you're having a hard time agreeing with the other parent, or maybe you have very different values as to what would be best for your kid. And that's when the court can be involved. Also, mental health professionals are involved in the court system in order to help the judge determine what's best for your kid, because the judge doesn't really know you, right? The judge gets to see you for maybe 20 minutes at the hearing with your attorney and then has to make this snap decision as what's best for your kid. And sometimes judges make great decisions, and sometimes judges make really poor decisions. Hopefully no judge is watching this. So, really what's best, if you have a kind of complicated issue or an issue involving mental health of your spouse, sometimes it's best to use a mental health professional. And what that mental health professional can do is they can do an assessment of the other parent and observe the other parent with your child and speak to collateral contacts, which may be our friends, family members, your kid's teacher, and better learn what's best for your kid. And then that mental health professional writes a recommendation, and the judge gets to read this recommendation in order to decide what's best for your kid. So when you have a more nuanced, complex situation, that's usually that's what we recommend you do in order for the judge to truly understand all the really important details that would need to be considered in doing that analysis to do what's best for your child. So, it's complicated. You might ask your friend, what do you think's best for my child? And that might be different than what you think, right? It's such a personal standard. It's such a personal analysis that it's really hard to know. I think the person that knows best what is best for your kid is going to be you, right? So as a client of ours, it's your responsibility to really tell us every single detail about your child and what's best for your child. If they have any medical issues, how they're doing in school, how close are they with their siblings, what are their friends like, do they have a good network where you live, what do they struggle with, do they have any special needs that we need to be aware of, are there any services they're using through the IEP. We want to know every single detail about your child and what you're doing in order to do what's best for them so that we can properly communicate that and advocate for you. We can tell the experts involved on your case, we can explain that to the judge if your matter is going to court, so the judge can make the right call. If we're able to negotiate a deal with the other parent, with the other parent's attorney, all those factors still deeply come into play. So the more you can tell us about what you believe is best for your kid, the more we will be able to fight for you and get you the results that are best for your kid, because that is the most fulfilling part of being a divorce attorney, is having a client hire us and get the results that their kids need in order to not just survive, right, but thrive, do really well in this world, in spite of the fact that their parents are going through a divorce.